So, let's start and say good afternoon, everybody, and welcome to the EDPS meeting with civil society on the European Union data protection reform. Together with my colleague, Assistant Supervisor Wojciech Wieworowski, I'm very pleased to see you at the EDPS. And the reason for this meeting is that, as you know, we are approaching the last mile in the European Union reform, and we have we have read with great interest your letter to the European Commission in April, the general message of which echoes what the EDPS has been saying on this subject, and therefore it's an honor for us to give you an additional chance to elaborate on your concerns. The EDPS is not only competent for supervision on European Union institutions, bodies, offices and agencies, but also exercise an advisory role, not only for the Commission but also for the legislators, a role which has been recognized by the Court of Justice in an important order issued, released in 2005. And we are contributing together with other colleagues in the Article 29 Working Party to the adoption of an additional statement from the European from the Article 29 Working Party. But in addition to that, this institution would like to release sort of an update to our 2012 opinion, very well known to all of you and posted on our website. 3 years after, it's time to evaluate the state of play and be ready to assist the co-legislators within the trilogue. So with full respect of the political will of the two co-legislators, we would like to collect additional concerns and information, and we would like also to implement the EDPS 5 years strategy, which was released on the 2nd of March this year. Our vision is quite clear in the document. We would like to, 20 years after the adoption of the Mother Directive, we would like to allow the legislator to update the current legal system with new generation of data protection provisions robust enough to last for at least 2 decades. We are trying to approach this issue with an innovative thinking by preserving our values. We have to consider that 20 years after the adoption of the directive, the current fragmented legal framework is not anymore sustainable. There is a need to consider new technologies of the past and being also future-oriented. And we also should consider better the implications of the Lisbon Treaty and the implementation of the Charter of Fundamental Rights. So by taking on board all these drivers, we would like also to see to which extent the current principles elaborated by the Commission more than 3 years ago may be effective against big data and the future challenges. In our viewpoint, it's time to consider data protection in a broader perspective by approaching to current safeguards in an innovative way, by thinking to data subjects as individuals, not simply because we buy, we consume, we subscribe, and by considering also the ethical dimension of data protection and the dignity of all persons being ubiquitous computing. But it's also time to reflect on global partnership, to analyze how this reform may better interact with the growing number of third countries approaching data protection, and how we can better interact with other sectoral rules, for instance, those in the consumer law or in the competition law, working less in silos. On top of that, as you highlighted in your letter to the Commission in April, there is, as usual, a risk with any co-decision process that certain provisions may be weakened and because of a compromise. In our viewpoint, values, safeguards cannot be negotiated as such. We have to reflect on what is effective, how we may be successful in reinforcing data subjects' rights, the accountability of controllers, the duties of data protection authorities in a modern way, by reflecting against new challenges what may work in practice. As a consequence, we will actively continue to contribute to the adoption of the 29 Working Party document, which is likely to be adopted in mid-June. And as said, around the presentation of our annual report early July, in time for the trilogue, we will release a position paper from EDPS with an evaluation of the state of play by highlighting the achievements and where present the relevant risks. But then we would like to also be pragmatic and with full respect of the political will of the main institutions, we would like to focus on what, on the basis of the experience and our effective experience, even on supervision, we would like to focus on what is best to be achieved. And therefore, we will propose specific solutions by focusing on the full text. Of course, we will consider the reform as a package, but in terms of timing, we will land first with comments, specific recommendations concerning the draft regulation. So before going live with this exercise, we think that being today in detail in listening mode and discuss with you what is key in the discussion would be extremely relevant. I'm here today with a qualified selection of staff members working in our teams, policy and consultation, supervision and enforcement, but also on new technologies, because they are working hard on each of these principles. They are very well connected with the rest of the EU bubble. But today we would like to hear from you, your voice, your concerns. It will be a technical discussion, and for the sake of transparency, but also to give visibility to this event. I think it's the first time that the new EDPS team meets the civil society, I really hope that this will only be the first round, although we only focus on the reform. I'm confident we will have additional chances to do another exercise on other relevant dossiers. May I suggest we now have a very quick tour of the table to simply introduce all of you, and then we can give you the floor on substance.
I'm Simon Davies. I've been working in the field of privacy for almost 30 years now, founder of Privacy International, the Big Brother Awards, and currently with a new initiative called Code Red, working with the whistleblowers.
I'm Diego Naranjo. I'm advocacy manager at the European Digital Rights.
Agustín Reina, digital team leader at BEUC, the European Consumer Organization.
David Martin Ruiz, senior legal officer at BEUC.
I'm Floris Krijken. I work on data protection at Bits of Freedom, a Dutch NGO for digital rights.
I'm Estelle Massey. I'm policy analyst at the Access Brussels office.
Reagan McDonald, European Policy Manager at Access. We're an international digital rights organization based here in Brussels.
I'm Joe McNamee, Executive Director of European Digital Rights.
And I'm Anna Fielder. I'm a trustee and board chair of Privacy International and also work as a policy advisor to the Transatlantic Consumer Dialogue.
Wojciech Wiewiórowski, European Data Protection Assistant Supervisor.
May I also ask our qualified staff to brief introduce themselves, please?
I'm Christian Dekina. I'm policy assistant in EDPS.
My name is Achim Klabunde and I'm the head of the IT policy sector in the EDPS.
Hello, my name is Anna Buchter and I mainly follow the reform project at the EDPS, Policy and Consultation Unit.
My name is Gabriela Zanfir. I am a legal officer in the Policy and Consultation Unit of the EDPS.
My name is Nora Mari. I'm a trainee at the European in the Enforcement and Supervision team.
My name is Zsuzsanna Belényesi. I work mainly on big data and on Working Party 29 matters.
My name is Delphine Roux and I work in the Supervision and Enforcement Unit.